Welcome back to my channel. I'm making this video after a very long gap with the courts reopening. Work has been slightly hectic. However, today I'm going to talk about a very important topic in criminal jurisprudence, that is anticipatory bail. Now, fundamental rights ensure that liberty is protected by state personal liberty, that is. However, under criminal jurisprudence, especially bail matters, an individual's personal liberty are directly touched upon. And it is abundantly clear that the law of bail is to strike a balance between an individual's right to liberty and also the need of the society to maintain peace and order. The courts typically have to balance out the need to restrain individuals who are capable of committing crime again, and also at the same time an individual's liberty so far as presumption of innocence until proven guilty is concerned. Now, pre-arrest bail as a concept was introduced in CRPC around 1973, which intended to avoid the harassment and humiliation meted out due to arrest or detention. Pre-arrest bail came to be known as anticipatory bail under section 438 of CRPC, and the object was that the moment a person is arrested, he shall be released immediately on bail without being sent to jail. Now, Supreme Court in BALCHAND JAIN versus State of MP has stated that the expression anticipatory bail is a misnomer. It is not as if the bail is presently granted by the court in anticipation of arrest, whereas when the court grants anticipatory bail, it makes an order that in the event of arrest, a person shall be released on bail. Now, once a person moves to the court on apprehension of arrest in a non-bailable offence, the court then has to evaluate the averments and accusations available on record and satisfy itself with whether the apprehension of arrest exists or not. Typically, the court gives an interim bail and issues notice to the public prosecutor. At the time of final hearing, the court may then either reject or confirm the bail. In the event that the applicant misuses the liberty granted by the court, then the complainant or the public prosecutor can approach the court for cancellation or modification of bail. A person has to satisfy two requirements before moving an application. First, there must be an accusation of him having committed a non-bailable offence, and secondly, existence of reasonable belief that he may be arrested. Now, in terms of jurisdiction, section 438 contemplates two forums for moving an application of anticipatory bail, that is the High Court or the Sessions Court. Now, both have concurrent jurisdiction to entertain an application for anticipatory bail, although the High Courts have generally held that Sessions Court should be approached first. Now, it has been observed by various High Courts in catena of judgments that High Court cannot entertain section 438 applications as a matter of routine without examining whether there are any special reasons to entertain said applications. Now, a bare reading of section 438 shows that it has not put any embargo to approach the Sessions Court first. However, as a matter of practice, Court of Sessions should be approached first for grant of anticipatory bail. There has been much discussion on territorial jurisdictions as well, and various high courts have said that it can still grant anticipatory bail for a short term till such time that the individual appears before the appropriate court having territorial jurisdiction, while other high courts have held that territorial jurisdiction of the Sessions Court or the High Court should be invoked where the case has been registered. Now, one of the earliest case of Constitution Bench of the Honorable Supreme Court on the subject of anticipatory bail was GURBAKSH SINGH SIBBIA versus State of Punjab, where the Constitution Bench of Honorable Supreme Court had elaborated on the legislative intent and conferring of wide discretionary powers to both High Court and Session Court in matters of anticipatory bail. The bench also had held that there is no potential of taking away from the investigating agency the power to conduct investigation in full and effective manner. In BALCHAND JAIN, it was observed that section 438 of the court is an extraordinary remedy and that it should be resorted to only in special cases. However, the Constitution Bench also explained specific issues to be borne while granting anticipatory bail, that section 438 is applicable only to non-bailable offences, and registration of an FIR or a case is not important for invoking of jurisdiction under section 438. Also, any order which is passed under section 438 cannot be considered as a blanket order, and most importantly that the duration of an order under section 438, it is not necessarily limited to any point of time. Although this point has been elaborated in SALAUDDIN ABDULSAMAD SHAIKH versus State of Maharashtra, where it was held that duration of an order under section 438 should be limited, and ordinarily the court granting anticipatory bail should not substitute itself for the original court which is expected to deal with the offence. Finally, in SIDDHARAM MHETRE versus State of Maharashtra, the Supreme Court laid down some very firm guidelines to be followed while entertaining applications under 438. Now, it is clear that the courts should not restrict the ambit and scope of section 438, which was not envisaged by the legislature. The court was supposed to still lay down important parameters like gravity of the accusation, whether the complaint which is filed was correct, is there a flight risk, possibility of repeat offence. Also, arresting, is it only to humiliate the applicant, or prevention of unjustified detention, or is there a chance of tampering of witness, or threat to complainant. Very recently in BHADRESH SHETH versus State of Gujarat, with respect to careful examination of the complainant and also to ensure that no false and frivolous complaints are filed, a complainant should be made aware of the repercussions of filing a false case. It was also said that it should not be such that anticipatory bail should be considered to be a special case, and that a person who is the applicant has to make sure that there is a special case made out. As a matter of fact, there should always be presumption of innocence, and interim bail should be given and notice to be issued to the public prosecutor. Now, there are different arguments also about anticipatory bail, specifically relating to denial to the police officers of custodial interrogation, and therefore a lack of full investigation taking place. However, in a society where arrest process is highly abused and jails are filled with under trials, pre-arrest bail should be given a liberal interpretation. Thank you so much for watching my video today. If you have specific queries with respect to anticipatory bail, please feel free to write to me, leave a comment, like my channel, subscribe to my channel, and do share this video if you like it. You can always send me your specific queries, law students and lawyers, if you have, with respect to citations of these cases. Thank you so much and take care. Have a wonderful day.